Hey everyone, it's Professor Robert Romano again. I just wanted to continue on with this week's lesson. So far, we've talked about law, where we get our law from, our sources of law. We decided that there are 4 to 6 sources of law in the United States. We get our law from common law, prior cases, constitutional law, statutory law, administrative law. We also get executive orders and we get some form of law from treaties. So, on that note, I want to continue with this week's lesson regarding the different types of law we have here in the United States. Basically, we have two types: criminal law and civil law. Criminal law. What is criminal law? I always ask that question. If you're in my face to face class, that's basically how my classes are run. Whoa, what is this? But what is criminal law? What makes something criminal? And the answer is easy. It's a body of law that identifies what behavior we as a society decide is criminal in nature. So we as a society determine that we don't like this. So we are going to make that criminal. We will punish somebody if they engage in that kind of activity, in that kind of behavioral activity. But the second part of criminal law is that it has to stipulate what penalties are in place for such violation. So there's two parts to every criminal statute, right? There's the law which we identify as criminal behavior, and then there has to be the punishment that you will be placed upon you if you engage in such behavior. Okay, so there's a part and a B part. In criminal law, it is the state or the government on behalf of the people that brings the action against a criminal defendant. All right, so it's the state. Private people cannot bring criminal actions. It's the state. When I say state, I mean the government. That's the city, state, or federal government that brings an indictment or an arrest warrant against the alleged criminal defendant. A private person cannot bring a criminal complaint against somebody. They can bring a civil complaint, but not a criminal. And when criminal law is broken down into two categories: misdemeanors and felonies. Take a moment to think, what's the difference between the two? Well, relatively easy. Misdemeanors are minor crimes. All right, they're crimes that are punishable by a year or less in jail or a fine. Felonies, on the other hand, are punishable by more than 1 year in jail. All right, so you have your misdemeanors, which are punishable by less than 1 year, and your felonies, which are punishable by more than 1 year. Okay? So the second part of a criminal statute, what penalties apply, make it a felony or a misdemeanor. Some examples of criminal law: arson, extortion, breach of peace. Think about yourself. What other crimes are out there? Murder, manslaughter, jaywalking. So there are a plethora of criminal laws out there on the books, and they are divided into some are misdemeanors and some are felonies. In criminal law, in all law, there is a burden of proof. So when the state brings a criminal case against an alleged defendant, they have to prove their case. On the criminal side, the standard or the burden of proof is beyond a reasonable doubt. That's the standard used in criminal cases. So beyond a reasonable doubt, what does that mean? That means that the jury can have no doubt that this person committed this act. They have to be 99.9% certain that the criminal defendant engaged in this criminal act. There's no doubt. Okay? The second burden of proof or standard of proof is clear and convincing evidence. There is some doubt, but for the most part, you believe that this person engaged in this conduct or this company engaged in this conduct. Clear and convincing evidence is used a lot in administrative appeals, administrative agency hearings. And if you're going to put a value on it, it's like 75% sure that this person engaged in this activity. So burden of proof in criminal cases is beyond a reasonable doubt, 99.9% sure. Clear and convincing evidence used mainly in administrative hearings and in other venues, but it means, there's some doubt in my mind, but I'm certain that they did it. Yeah, 70. You can put a number value on it, 75%. And then for civil actions, civil cases, this burden of proof or the standard of proof is a preponderance of the evidence. And that means there's a lot of doubt. They may not have done it, but I'm certain that they did. You put a value on it, you're 51% sure that this person engaged in this conduct. And preponderance of evidence is used in civil cases, car accident cases, slip and falls, defamation cases, and the like. All right, so you have criminal law, which uses the hardest or the strictest standard or burden of proof, which is beyond a reasonable doubt, all the way down to civil cases where the burden of proof is by a preponderance of the evidence. Civil law, as opposed to criminal law, is law that pertains to civil or private rights that are enforced by civil actions. Right? These are private rights. These are your rights, as opposed to criminal law, where it's the state or the government that brings the case. In civil cases, it's your right. It's your right to bring the case. All right. They're non-criminal matters, and they could be between individuals. Myself against one of my students. My students, more likely, my students against against me. Students against St. John's. It could be between an individual and an organization. It could be between two organizations, two businesses, the government, and so forth. Okay? So civil law are non-criminal matters, private matters between individuals, organizations, businesses, or government, or any mix of all of them. In a civil action, it is the plaintiff who brings the case. Okay? The name of the person who brings the action is known as the plaintiff. They are the person, group, organization who brings the lawsuit. They feel that they've been wrong somehow, and they need judicial intervention to correct this wrong. All right, so let's say, hold on, Romano, hello. So let's say you lend somebody some money and they promise that they would pay you back. They failed to pay you back, so you sue them. You're the plaintiff. You bring the action because you feel that you've been wronged. They didn't pay you the money back. So they wouldn't do it, so you ask the court to step in and force them to. The name of the person who's being sued, or the group that's being sued, or the organization that's being sued, is known as the defendant. All right, they are the one who have allegedly committed the wrong act. Okay, they may not have, but they are the ones who have allegedly committed it. All civil actions start by filing what they call a complaint. Okay, it's the document which begins the lawsuit. The complaint details what facts the plaintiff believes justifies their claim, and also what damages they are seeking. Okay, they can be seeking monetary damages. They can be seeking an injunction or stopping somebody from doing something else. So they clearly point out the details of the case and what remedies they want or what damages they want. They want their money back. All right, you lend somebody $10,000, you want your $10,000 back. It provides enough information so everybody knows what's going on. The defendant knows why they're being sued. Oh yeah, on January 27th, I lent Rob Romano $10,000. He didn't pay me back. Okay, now I know. Civil causes of action, some are breach of contract, like we've been talking about, negligence, car accident cases, malpractice, legal, medical, sports context, a fan hit by a baseball, and his fan sitting in the seats hit by a baseball, hit by a bat, fan hit by a soccer ball. A lot in sports, employment law. Employment is our law is considered civil. Landlord-tenant, if you get an eviction or an eviction notice, that's a civil cause of action. Eminent domain, which we'll talk about in more detail during the semester. Foreclosures is another form of civil action. All complaints are served by an indifferent person. So that complaint has to be served on the defendant by an indifferent person. Someone not involved in the case. That's usually a sheriff or a marshal. They serve the complaint, the writ summons, on the defendant, or to notify them that they are being sued and what time they have to respond to this lawsuit. You don't want the plaintiff doing it because you don't know if the plaintiff's going to do it. All right, so the courts require that it's done by a different person who will swear out an affidavit that they actually served this complaint on this person. Okay, litigation. This complaint starts the litigation. Right, the litigation is a process of bringing, maintaining, and defending against lawsuits. All right, now when you file that complaint, you are in litigation. All right, you're in the process of bringing, maintaining, and defending against the lawsuit. Litigation, so you guys are aware, is very time consuming. So when you get out there to be sports managers, realize litigation is time consuming, it's expensive, and it's extremely difficult. The courts have a complex procedural rules that lawyers get paid big money to understand. All right, so if you're out there and you're working in the sports industry and litigation is on the horizon, realize that it's going to be very time consuming. It's going to take up a lot of your time producing documents, spending time in court, depositions, and whatnot. It's very expensive. Lawyers aren't cheap. We aren't cheap. We bill anywhere from $250 to $800 an hour. I'm somewhere in the middle. And it's difficult. I mean, litigation is difficult. Lawyers get paid big bucks because the rules are complex and they understand them. In the United States, we have two major court systems: the federal court system and the state court system. Two different levels of court. Okay. State courts are in all 50 states, and in D.C., the District of Columbia has their own court system. So, state court systems are broken down into two sections: limited jurisdictional courts and general jurisdictional courts. And you all know what this is, you all have heard it, but limited jurisdictional courts are just that. They're limited. They have limited jurisdiction. They have limited ability to hear certain cases. Traffic courts are, for instance, a limited jurisdictional court, right? They only hear traffic cases. They only hear if you ran the red light, if you didn't use your blinker, if you didn't stop at that stop sign, if you didn't yield properly. They can't hear antitrust matters. Okay? They're limited to traffic issues. Juvenile court. Courts set up for juveniles. Right? They can't hear adult cases at all. Justice of the peace. Usually go there to get married or get a document signed and notarized. Probate courts. Limited jurisdiction. They just review wills or intestate proceedings. Right? They can't hear civil matters, but they review wills, that kind of stuff. Small claims court. Usually limited jurisdiction in the amount of money you can sue for in this court. In small claims, usually the cap is about $5,000. Could be $2,000, $5,000, depends on the jurisdiction. So anything over that has to go to a general jurisdiction court. Limited jurisdiction courts, evidence is introduced. Even though it's limited, there is evidence that is introduced, and testimony can be provided. However, usually there's a record, but there's no transcript. All right, there's no stenographer there recording all that is being said by the parties. There's a record, there's some evidence of what the court decided, but there's usually no transcript. Is it appealable? Are limited jurisdictional courts appealable? It depends. Yes, for the most part, yes, but sometimes no. So you can appeal it to a general jurisdictional court. For the most part, there are some exceptions to the rule. General jurisdictional trial courts are courts of record. All right, criminal courts and civil courts. So there is a record of the proceedings. So if you're in front of the judge, it is all being recorded or being taken down by a stenographer. In general jurisdictional trial courts, testimony is provided. All right, people get up on the stand and they do testify, and they're cross-examined. Evidence is presented. There is a record, and there's always a transcript. And in general jurisdictional trial courts, the rulings are appealable to a higher court. And you appeal them to an appellate court. Okay, the appellate court hears the appeals from the trial courts. That's their job. They hear appeals from trial courts. No evidence, however, no new evidence is presented in an appellate court. Right? There's no new testimony. There's no new documentation being entered. Only the evidence that was submitted at the trial court is reviewed. There's no testimony of witnesses, and usually the appellate courts You submit briefs, you submit, and you have some oral argument. But again, no further testimony of witnesses, no evidence is presented. And appellate courts only hear issues of law. All right, they cannot redefine the evidence. All right, there's no new evidence presented, so they only hear issues of law. All right, not evidence. They determine if the trial court misapplied the law or if the trial court applied the appropriate law or not. Okay, so that's the appellate court's role. They only hear issues of law. Determine if the trial court misapplied the law or if they applied the appropriate law to the proceeding. They may have put the wrong law in and came up with a wrong answer. Okay? It's very technical. I'm not going to go into too much detail on it. Appellate courts, there's a record, there's a transcript, and if you're not happy, you can appeal to a higher court, and that higher court is the state Supreme Court. And again, state Supreme Court hears appeals from the appellate courts and certain trial courts on certain issues. You can appeal directly to the Supreme Court case, to the Supreme Court your case, and that's it. Okay, so that's the state court system in a nutshell, very quickly. Second system is the federal court system. All right, we have our state court system, which hears mostly state issues, state law, and then there's the federal court system, which hears federal issues, federal law. Federal court system is broken down into 4 levels: special federal courts, U.S. district courts or trial courts, the U.S. Court of Appeals, which is their equivalent to the appellate court, and then the U.S. Supreme Court, which are those 9 judges that sit down in D.C. and lately you've been given some interesting decisions. Federal court system, special federal courts. These are limited jurisdictional courts, similar to the state court system. The U.S. Tax Court, U.S. Claims Court, where you have to, if you're going to sue the United States, you have to go there first. U.S. Bankruptcy Court, those kind of courts. Special federal courts, limited jurisdictional courts. The U.S. District courts, here similar to the state courts, hear testimony, evidence is presented, and they determine issues of fact and they determine issues of law. The U.S. Appeals Court, again, like the state court, appellate courts, only can hear issues of law. No new evidence can be submitted. There are roughly 13 circuits throughout the United States. In New York here, we're the Second Circuit. And then there's the U.S. Supreme Court. You can appeal, if you're not happy at the appellate court, you can appeal to the U.S. Supreme Court. But they don't have to take your case. No, they don't have to take your case. They have the discretion to hear your case or not. A lot of times they can say no. And then again, if they do decide to hear your case, there's no new testimony. They will only listen to issues of law. All right? Any questions? Please let me know. There's the readings that are still posted. So I want you to go over those. Read the Michael Vick, Roger Clemens indictment and the Michael Vick plea agreement. If you have any questions under those, or you want a short video summarizing or giving you an overview of those 2 documents, email me, let me know. I'd be happy to put a brief 5-6 minute video on those two documents to explain them a little better. But please let me know. On Wednesday this week, tomorrow, I will be posting discussion questions, so start looking out for those and start answering those. And those discussion questions will be on the Michael Vick plea agreement and the Roger Clemens indictment. Okay, take care.